Steve Brown, Tips, Traps and Tactics of Buying a Business. During this session we'll be looking at a number of things such as taking instructions, issues to consider when taking instructions, pre-draft and contractual representations, some issues of drafting business contract of sale or refresher, specific contractual terms and conditions, the negotiation process, and a quick review of due diligence in the context of buying and selling a business. One of the most important things to consider as a lawyer is taking instructions. We need to find out what it is our clients want. We need to be goal-orientated and focused on achieving what it is the clients want from the particular transaction. It's trite to say a vendor wants a sale and a purchaser wants to purchase a business. What we need to do as lawyers is to facilitate a successful transaction. And for that to happen, we need to find out what it is that the vendor is selling and what it is that the purchaser wants to obtain. The use of a checklist in taking instructions is very useful. It can minimise our exposure to professional negligence claims by making sure or endeavouring to ensure that we do not miss asking a pertinent question or looking at a particular issue. In taking instructions, we should only ever act for one party. It is very difficult to try to act for both vendor and purchaser. If everything goes well, then there for the luck of God go you in getting the transaction done. But should the matter become contentious in any way, and there is a great deal of tension between the vendor and purchaser concerning a particular element or aspect of the sale and purchase, then where do your interests lie? Who do you prefer over one or other of the parties? Consequently, acting for both parties in a sale transaction is just fraught with danger and should be avoided at all costs. If you are not a tax expert, when considering the instructions you're taking, work closely with your client's tax advisors. In the aspects of a vendor, consider the capital gains tax, how best to structure the vendor for the sale. In many cases, a few months, if indeed not even 12 to 18 months, preparatory steps may be required for the transaction to be properly structured. So far as the purchaser is concerned, similar aspects need to be considered on a case-by-case basis. The issues to consider for vendors in taking instructions are to consider what assets are in fact being sold. I've often found that some of the business assets are not actually in the name of the vendor. This is particularly relevant where there are transactions with intellectual property. Many vendors will set up their structures in such a way where the intellectual property assets are either held by themselves in their name or for asset protection reasons are held by them through a trust, and those intellectual property assets are then licensed to the vendor's trading entity. It is therefore important in selling an entire business arrangement to sell not only the day-to-day business assets, but the rights to the intellectual property, which are the pivotal asset that drives the business forward for so far as the purchaser is concerned. The other issue to consider is that the benefit of obtaining a guarantee. from a particular purchaser at any point in time. It's important that this be considered up front, because it can be that a purchaser will not do what is required, or a vendor may not do what is required. A case that illustrates the benefit of obtaining a guarantee is the case of Swept Up Marketing Proprietary Limited and Voltrant number 282 Limited. This was an unreported decision of the New South Wales Court in 1989. The case concerned the sale by Swept Up to Voltrant of a public relations business. The vendor leased various chattels for the use in the business, such as word processors, photocopier, and a telephone system. The sale agreement required the purchaser to take over all of the obligations under the lease agreements of these particular items of equipment. The purchaser, on taking the business, had the benefit of the leased assets, but failed to take an assignment of the leases, which with the asset suppliers, and the vendor was forced to continue to make the lease payments. The leases were not assigned because of the failure of the purchaser to provide necessary information to the lessor of the equipment. The vendor sued the purchaser and its director, Mr. Booth, who was a guarantor of the purchaser's obligations under the sale agreement. The guarantee provision was simply drafted, and it read as follows, quote, Mr. Booth hereby guarantees the due and punctual performance of all of the obligations of the purchaser to be performed and observed under this agreement, which guarantee shall not merge on completion, close quote. His Honour Justice Cole held that the purchaser and guarantor were liable to reimburse the vendor for the lease payments and the interest paid thereon. His Honour Justice Cole also found that Mr. Booth, the guarantor, was liable for all future payments under the leases in default of payment being made by the purchaser. So the Swept Up case illustrates how important it is to obtain a guarantee, no matter, even though it's a very simple and straightforward principle to put into the contract. Issues to consider on behalf of the purchaser is, does the purchaser have the funds to fulfill their obligations to meet the purchase price? Does a client who is a purchaser have the capacity to run the business? Although we're not strictly in the role of giving financial advice, the exercise of common sense is often useful. There is no point in assisting a purchaser client to take over a medical practice if they're not indeed a medical practitioner. In fact, unless of course they're going to just operate the business and have contracts with doctors to do the work. So using and exercising common sense in the advice we give is certainly important. We also need to give consideration about the legal structure to be considered. An example of this is in the case of Gallagher and Carmen, 1990, Australian ATR 81011, illustrates the importance of giving careful consideration to the structuring of business being purchased. In that case, the purchase involved a liquor store business and freehold land. The liquor licence of the vendor was an unconditional licence, and as a matter of practice or practical reality, 80% of all liquor sales through the particular business were to wholesalers, other licensees that sold liquor. The licensing court agreed to transfer the licence to the purchasers, but imposed a condition requiring that 90% of the sales be made to wholesalers of liquor and not to the public. The purchasers, therefore, were in a situation where they had acquired a business where the structure was 80% to wholesales and 20% to the public, but on transfer of the liquor licence, 10% of their revenue from the public was being denied as being able to be acquired by them. The purchasers subsequently resold the business at a loss and sued their solicitors for negligence in failing to advise them that the restriction issue imposed by the licensing court could have been avoided if the purchasers had have acquired the shares in the vendor company rather than just acquiring the business assets. So the Gallagher and Carmen case is a clear illustration of how understanding what the legal structure is of not only the purchaser but the vendor is important in determining the advice given to your clients. We will now look at the considerations in more detail as to what we need to look at in determining the structure. First, we should look at the simplicity of the vehicle and its cost of establishment. Second, the nature and the size of the business. Is it appropriate that a sole trader operate the business? Partnership, corporation, trust. Should there be asset protection provisions put in place prior to a purchaser getting involved in the particular business? What's the potential for growth of the business? What will the needs, immediate and long-term needs for additional working capital be? What are the current taxation consequences of the particular structures that are being considered? Are there better ones? What's the manner in which the owners of the business will be involved? Will they be actively involved? Is it a sole director, sole secretary, sole employee business? Or will there be a board of 10 directors, multiple managers and hundreds of employees? What is the cost and complexity of terminating the particular structure once it's put in place? Many people that I've seen put fabulous structures in place but have no regard to their succession planning on how the particular structure will be decompiled when they wish to get out of the particular business venture. And often that can be more onerous than putting the structure together in the first place. What's the structure of the purchaser's family? Are they all going to be involved? Is this a family business? Is it a business for others to be involved in? And what's the potential of failure? What are the implications? And again, we have to look at asset protection. The choice of vehicle structure is generally complicated. It's further complicated not just by the law, but by existing family and commercial arrangements that exist. Often it is necessary to take into account the purchaser's existing assets, income, taxation position, bank and security and other business structures in determining the most appropriate structure for a new business venture to be undertaken in. We can see on this slide the various forms of structure that can exist: sole trader, partnership, operating through a corporate trust or individual trust, and the corporate structure itself. There are various pros and cons for each of these, and there will be various taxation considerations that need to be taken into account. Often, what one may think is the best advice may not always be the most practical. For instance, as lawyers, we would often say it's best to get the protection of the corporate veil. Establish a corporation and the directors and shareholders behind it will have limited liability through their shareholding, so that the capital that they contribute will have that limited liability unlike a partnership where it's unlimited, and the directors will have a degree of protection from any contractual or professional indemnity claims. However, if the directors are going to be involved and they're going to be employees, then what will the additional costs of their salaries have with workers' compensation? Might it be better if there is a partnership where the partners get profit distributions rather than income that will limit the workers' compensation that has to be paid? It could also limit in the short term payroll tax obligations. True, it will arise personal liability, but if the particular client does not have sufficient working capital to be able to make the PAYG payments as you go, advising them to have a company from the outset may impose upon them practical restrictions which could be avoided through the use of a partnership or sole trading vehicle. So looking at the pros and the cons and doing a sensitivity analysis on the structure, whilst time consuming, is an important role that as lawyers we need to undertake on behalf of our clients. The negotiation issues that need to be considered pre-contractually is in negotiating, what are we looking out for? And we'll deal with this a little bit more when we look at the due diligence process. Have regard to misleading and deceptive conduct issues, both as vendor and as a purchaser. Be conscious of not engaging in anything that could be construed as unconscionable conduct within the meaning of Part 2.2 of the Australian Consumer Law, or engage in any unconscionability conducts that could be subject to review under the New South Wales Contracts Review Act. As an overview and reminder, remember that misleading and deceptive conduct is a strict liability provision within Section 18 of the Australian Consumer Law. Actual deception does not have to be proven. It's the overall impression to the target audience that is critical as to whether there is or is not misleading and deceptive conduct. A sales puff, product puffery, is permitted to some degree. What you do not say through silence can itself create a misleading and deceptive cause of action. Ambiguity can cause misleading and deceptive conduct, as can erroneous assumption and half-truths. The 4 basic principles to consider in establishing whether there is misleading and deceptive conduct is to consider the relevant section of the public that must be identified. Are all people within that section sufficiently intelligent and educated to understand the message that's being conveyed to them? Evidence that someone was actually misled is not relevant. It's a matter for the court to determine whether the particular statement or silence is of itself misleading and deceptive so far as the court is concerned. And when a misconception has arisen, it is important to determine why, in order to see if the business conduct or the person who made the representation caused it, or whether it arose through some other cause of action. Another and secondary principle, it's the overall impression on the target audience that counts. And that's what we need to consider. We will look at that a little bit later on in looking at a case of Collins and Hengco. In our drafting refresher, we need to consider that not all agreements are contracts. Many parties, when involving in themselves in business, will put together a heads of agreement, term sheet, memorandum of understanding. These can be contractual and binding if the parties wish. They can be contractual and binding where the court determines that there's been an offer, acceptance, consideration, intention to be legally bound, and the parties have the requisite capacity to have formed a contractual relationship from the particular agreement that was entered into. However, if you do not want the particular agreement to be binding, then say so. It's very important that the court understands where you're coming from. Some examples of a non-enforceable agreement is, if you wish, will you wash my car? I'll give you $10. Here you can see a parent talking to a child, giving them a sum of money. Clearly between the child and the parent, they think it's to be a legally binding agreement, but obviously the capacity here is not such, the circumstances are not such that it would arise as to be legally binding. It's purely a morally enforceable agreement between the parent and the child. Another example we can see here of a non-enforceable agreement is, I'll pick you up for dinner at 8 o'clock. There is no binding contractual relationship if the person making the offer to take the other person out for dinner fails to attend. They may not get another chance. However, the ability to contractually enforce this particular agreement is not one the courts will entertain. We've seen that contracts are agreements, and therefore putting this in the context of buying a business, we should look at the practical answer to the question. What is a contract from a practical sense? And the answer to that is that a contract is a risk minimisation tool. And it becomes a risk minimisation tool by being structured as a checklist or rule book that applies or is applicable to be able to apply a performance standard. Contracts and agreements become risk management tools in this particular way. If we were to have an agreement for a long-term supply contract, having regard to the nature that it's of its very nature long-term, there may be many managers of that contract over time. Therefore, it's practically and commercially important that the agreement between the parties is documented so that over time, what was agreed at the beginning of the relationship is understood throughout its long term. On the other hand, the contract to purchase an apple. We could enter into a written agreement with the fruitier that we require an apple that has a 15 decibel crunch, that has the luminescence of a ruby under a moonlit sky, and has the taste of that apple that I tasted at Normandy on that particular wonderful holiday. However, trying to find the fruitier that would enter into such a contract would not be worth the time, trouble and effort that would be required to do so. Therefore, we minimise our risk by saying, apple, $1, $2, I'll take my chances, I'll pick one that I think looks satisfactory to try to satisfy my hunger, and if I'm successful, well and good. If not, then I will take the particular risk. Similarly, going forward to look at a contract or agreement to sell a manufacturing business. In that particular situation, we need to look at all of the aspects of what's being sold, to whom it's being sold, what assets are there to be sold, and how do we effectively sell those assets from the vendor to the purchaser. And how do we do this practically? The way we do this practically is to consider drafting the contract as a checklist of rule book and to look at 4 particular aspects or 4 particular questions. 1, who is to do what? Who is doing the selling? Who is doing the purchasing? Looking at the structures that we've just seen. When are the goods or services to be supplied? So in the case of buying a business, What is the vendor selling? What associated assets may need to be sold, as we discussed with intellectual property? What employees need to stay? How long do they need to stay for? Do we need restraints of trade? What is the purchaser buying? Shares from a structure? The assets? Other contractual relationships? Then we have to consider how will the business, assets, shares, as the case may be, how will they be paid for? Cash. Over time. Cash with shares. Cash with shares with options. The how is crucial to the particular transaction. And then, moving on, we can look at the consequences of poor or non-performance. If the money that was promised to be paid in 6 months' time is not paid, what do I do about it? Should I receive interest? Should I have security? Should there be a bank guarantee guaranteeing the payment in 6 months' time? As lawyers, these are all the issues we need to consider, discuss, and take instructions from our clients on. In doing this, we need to consider the risk return of the particular investment. So as you can see from this slide, in lease or less formal arrangements, we probably don't need a written agreement. In buying the apple, we probably and certainly don't. However, in acquiring business assets, shares, we do. In acquiring a factory with hundreds of employees, even 50 to 10 employees, we certainly need a contract which looks at capital gains tax issues, the transfer of contracts, the transfer of leases, the taking on of the responsibility for leased equipment or not, as the case may be. All of these aspects need to be considered from the low risk to the high risk, and we need to discuss them with our client and take the appropriate instructions. Our clients are often invariably have the ability to take risk. They're business people. Being involved in business is risky, and therefore we need to appreciate our clients' appetite for risk, and they are the ones who need to take it. It's not for us to take the risk for them. It's our job to inform them of what the risks are, to advise them of the likely prospects of such a risk coming to fruition, and for the client then to make a decision whether they wish to take that risk or try to avoid it in some way, shape or form. Now, having ascertained what the risks are and the chances of those risks coming to fruition, we need to then draft a particular contract. Before we do so, let's have a look at a refresher on how the courts interpret contracts, because how they interpret a contract is crucial for us in knowing what we do about how we draft a contract. The principal proposition that prevails under Australian law at this point in time has been reinforced by the High Court in the case of Toll and Alpha Farm. Courts interpret contracts using the objective theory of contracts. The objective theory of contract is that the rules of construction are pointers to discover the presumed intentions of the parties as determined by the words the parties themselves use, as a court believes the reasonable person reading those words would understand them. The courts do not look at or consider necessarily the actual intention of the parties other than those taken from the words themselves. So, in our refresher, the points we need to consider is that in contractual interpretation, the court's objective is in construing a contract is to ascertain what the mutual intentions of the parties were as to who was to do what, how and when they were to do it, as ascertained from the words the parties themselves chose. Consequently, if the parties to a contract cannot understand the clauses themselves, then they shouldn't be using them. Because ideally, the party should understand what the clauses mean, and therefore they will not need the aid of a court to understand them. So it's our job to make sure that the clients really understand what the clauses are about. The intention of the parties is the meaning of the words they have used. There is at common law no intention independent of such meaning. That is, it's not appropriate. There's no parole evidence rule. The client can't get up and say, by these words I meant. The court will look at the words and draw the meaning from those words without any aid memoir from the clients or the parties to the court case themselves. Accordingly, the intention of the parties must be ascertained from the words used in the light of the surrounding circumstances. But the surrounding circumstances will only be called into question when the words themselves are ambiguous in some way. And if they're not ambiguous, then looking at the surrounding circumstances is something the court will not embark upon. And as I've mentioned previously, the court will construe the objective intention of the parties, not their actual subjective intention. Accordingly, the words of a contract should be construed in their grammatical and ordinary sense, except to the extent that some modification is necessary to avoid absurdity, inconsistency, or repugnancy. The ordinary meaning of a word is its plain, ordinary, and popular sense, although the sense may be a sense amongst a particular group of persons. Where this becomes relevant is in using jargon or technical terms. It's important, in my view, is if you're going to use jargon or technical terms to define what those terms mean between the parties of the particular transaction. It's important for two reasons. One, you do not want to have a case later on where the words aren't defined, and you have to call in experts to determine what the words mean. The difficulty is, one, it's very costly to bring in the experts. Secondly, over time, the meaning which the particular jargon has within the contract may have changed. So the use of a word in the contract in 2000 may, in a technical sense, have transmognified to something slightly different, such that the true objective intention, if interpreted in 2000 by the use of a particular set of words, could have a slightly, or indeed even a dramatic different version in 2014. So to avoid such risk occurring, define the particular words so that clarity is obtained at all time. And that's important for the use of these technical terms and having a dictionary. In looking at the rules of construction, have regard to implied terms. Again, if there is adequate certainty, there will not be any need to have an implied term. In drafting, consider use of special and standard form contracts. The use of a standard form contract provides certainty of understanding between the parties. It can assist in a court in knowing the clear interpretation of what the clauses mean, and therefore limiting and minimising arguments as to the particular meaning of standard clauses. If, however, a standard clause is inappropriate, such as it's not appropriate for a particular reason to use the Law Society standard form of sale of business, then you'll need to draft your own. In doing so, you need to ensure that the parties are achieving what they want by adopting a checklist or rule book approach and bearing in mind that performance is the key issue. In the sense or case of buying and selling a business, what we are seeking to perform is the successful transfer, sale by the vendor of a business, as clearly ascertained as to what that is, to the particular purchaser. Having reviewed how to put the contract together in the light of a checklist approach, and having reviewed the principles of contractual interpretation, we'll now spend a little bit of time looking at some specific contractual terms and conditions that are important in a sales contract. It's important to have regard to these as tips, traps, and tactics. The particular provisions we'll look at concern goodwill, lease issues, transfer of employees, reduced deposit clauses, exclusion clauses, and early access. The first principle to look at is goodwill. In any sale of business, there is going to be goodwill. Goodwill is an incorporeal hereditament. It is a form of personal property which can either be retained or transferred. The courts have held that, indeed the High Court has held that goodwill has no value separate and distinct from the business to which it attaches. In Commissioner of Taxation and Murray, Gaudron, McHugh, Gummo and Hayne noted that goodwill is inseparable from the conduct of a business. It may derive from identifiable assets of a business, but it is an indivisible item of property, and it is an asset that is legally distinct from the sources, including other assets of the business that have created the goodwill. Because that is so, goodwill does not inherit the identifiable assets of a business, and the sale of an asset which is a source of goodwill, separate from the business itself, does not involve any disposition of the goodwill of the business. Consequently, it is crucial to identify the bundle of assets that give the goodwill to a particular business in order for the purchaser to adequately capture it. So we'll now look at some examples of goodwill. One example that we'll look at is where a company operates a business distributing high-value medical equipment in Australia. They develop important, crucial commercial and personal relationships with a German manufacturer. A purchaser of such a business will need to ensure that the purchaser takes an assignment of those contractual rights with the German manufacturer, but more importantly, from a commercial perspective, the purchaser will need to ascertain how the relationship that has developed between the vendor and the German manufacturer is going to be maintained and promoted when the purchaser takes over. If the purchaser has a pre-existing relationship with the manufacturer, that won't be so important. But if the purchaser is coming in and there is no pre-existing relationship, then this is a critical commercial consideration that needs to be addressed by the parties in the sales contract. Another example of looking at goodwill is that the vendor is selling a well-known convenience store. Local area, particularly busy, with lots of passing traffic and good parking. The residual term of the lease, though, is relatively short. So the goodwill in this sense is tied to the vendor and their relationship possibly with the customers, although as it's a lot of passing traffic, the goodwill is probably associated with the location. Therefore, the purchaser will need to have to ensure that it can renegotiate a sufficiently lengthy term of the lease to protect the goodwill of the asset that it's acquiring. Otherwise, the payment to the vendor may not be able to be returned over time if the lease were terminated. An electrical contractor servicing domestic customers is our third example of how do we address goodwill in a sales and business contract. The electrical contractors had considerable success in Yellow Pages advertisements over a number of years. The company has an easy name to remember, but the company name contains the surname of the vendor, which the vendor wishes to retain and doesn't wish to pass it on. So we need to have that as a consideration and work out how do we deal with this. So looking at the goodwill drafting options, how do we address these various examples? What we could look at is a retention fund. We can look at clawback provision. We can look at restraint of trade and non-competition clauses. And we can look at earnouts. Each of the particular clauses, these drafting options, have their pros and cons. A retention fund is where monies are kept aside, having regard to there being a risk of consumers walking away after the vendor leaves. It may be necessary to maintain a fund, a proportion of the purchase price, which is held in escrow either by the vendor solicitor or jointly by the vendor solicitor and the purchaser solicitor, from which money can be repaid to the purchaser should customers be lost through no fault of the purchaser. Is one option to secure goodwill. A second option are clawback provisions. A clawback provision arises where all of the purchase price is paid at settlement or within a relatively short space of time, but after a period of time when the purchase price has been fully paid, the purchaser, if certain events are not achieved, is entitled to a fixed or an ascertainable sum back through a clawback. These are generally tied to either specific representations or warranties, where the vendor warrants that certain things will arise, and if they do not come to fruition, the clawback provision is triggered and the money is repaid. Another way to protect goodwill is to have a restraint of trade or a non-competition clause with key members of the vendor's organisation to prevent them from immediately receiving the purchase price and entering into competition with the purchaser. And a fourth way is to consider the use of an earnout. An earnout provision is, rather than looking at a penalty or monies being refunded from the agreed purchase price, arise from the purchaser receiving benefits or increases in value through the vendor and purchaser working with one another to increase the return to the vendor. A particular example that I was involved with a number of years ago was with a client that sold a magazine. The demographics were to adolescent girls in particular, ranging from 11 through to about 15, 16. The magazine had a masthead and branding, and Fairfax were looking at acquiring it. They offered a sum of money and the vendors thought the sum of the money was acceptable. However, they said that they believed that they were in a growth phase and that it ought to be higher. After some time, it was possible to increase the purchase price by a bit, but Fairfax weren't prepared to pay more than that slightly increased amount. We then went back to them and said, okay, we'll accept the slightly increased amount, but we will stay, that is the client will stay involved over 5 years, and we suggested key performance indicators that should these key performance indicators be met over the next 5 years, that in addition to the purchase price being paid immediately, a further amount, which was indeed 25% of the total purchase price that was going to be paid, would be paid. Fairfax, the purchaser, was very comfortable with this proposal because they were seeing that the vendors were genuine in their desire to give a return to the purchaser. Moreover, they took it on board that the vendors genuinely saw that the business had not hit its zenith and that there was the ability for further profits to be earned, thereby benefiting both the purchaser and the vendor. Earn-out clauses are value additive generally to both parties. The vendor, though, will have to take the risk of possibly getting less money up front, but with the possibility of earning more at a later point in time. The critical aspects of an earn-out clause is to get the KPIs in an objective form, in a form which cannot necessarily be adversely manipulated by the purchaser to the detriment of the vendor. And structuring that can be interesting and challenging, but fun at the same time. Another aspect of the clause are the lease of premises. So in the example we had of the local convenience store, ensuring that the goodwill that was attaching to the premises is maintained will only be secured by obtaining a new lease. Now, this may not seem overly important, but it is crucial if you are obtaining locally situated or premise-related goodwill. Employees. A lot of businesses' goodwill is dependent upon the employees, and therefore ascertaining and maintaining employment contracts with the key employees that maintain the goodwill with customers and clients or suppliers, as the case may be, can be crucial to the success of a purchaser obtaining a business. Therefore, ensuring that as a condition precedent to completion, that certain key employees enter into contracts of employment with the purchaser can be important provisions to negotiate and draft into a contract for sale of business. Other issues to consider in drafting a contract are the terms and conditions and looking at a reduced deposit clause. Reduced deposit can also be related to delayed payment. And a case that needs to be considered is that Ianello and Sharp. It's a 2007 New South Wales Court of Appeal case. And in this particular case, there was a reduced deposit clause. And the New South Wales Court of Appeal looked at the clause which read as follows: 14, reduced deposit. Notwithstanding anything else herein contained, the vendor shall accept on exchange of this agreement payment of $225,000 being part of the deposit, which in this case was half. The parties expressly agree that if the purchaser defaults in the observance or performance of any obligation hereunder, which is or has become essential, the balance of the deposit, namely $225,000, shall become immediately due and payable, and the purchaser shall forfeit the whole of the sum of $450,000 pursuant to Clause 9 hereof to the vendor. The court held that the obligation to pay the second $225,000 when the purchaser failed to complete was inconsistent with the characteristics of what a deposit was. The court held that notwithstanding that the purchase price said that it was 10%, the fact that only a 5% deposit was taken meant that that was the deposit, and this additional promise to pay arising on default was not able to be enforceable. This may be similar to the position of the recent High Court case in Andrews and ANZ dealing with penalties. The court didn't categorise the additional payment of $225,000 as a penalty, but it would appear to me that there is certainly a line of authority now relying upon Andrews and the ANZ where the penalty argument could be argued in addition to the ratio of Ianello and Sharp. So how do we overcome these particular issues? Well, what we can do is to minimise the penalty issue, never reduce the deposit. Take the amount that you agree upon. You would have to be firm. Another option, though, is to take a cash payment but take the additional deposit sum either by way of bank guarantee, personal guarantee, or the use of a promissory note or bill of exchange. We've probably forgotten as lawyers the use of promissory notes and bills of exchange, but in this way the promissory note would be a separate and distinct contract. You would receive the full 10% deposit. You would then have a sum certain which could be sued at a later point in time, and the underlying contract that the promissory note was given for should not be considered when seeking payment upon the promissory note. Therefore, it avoids the issue of whether it is or is not a penalty. And we've certainly used that in a number of cases, and it's been satisfactory. When drafting a contract for the sale of business, you also need to have consideration of exclusion clauses. You can't contract out of Section 18 or the old Section 52 of the Trade Practices Act. So the entire contract clause that we're all very familiar of, such as in entering into this agreement, the purchaser acknowledges that it has not relied on any statement, representation or warranty by or on behalf of the vendor, whether expressed or implied, which is not otherwise contained in this agreement, can't be contracted out of. And a case that illustrates this is that of Collins Marrickville Proprietary Limited and Henchco Investments Proprietary Limited. And I mentioned that we would come back to this case later on when I referred to the use of Section 52 in the case of silence. The Collins Marrickville case is an excellent case to have a look at as a case example. In this particular situation, there was a deli known as the New York Deli in Double Bay. It was advertised for sale as licensed restaurant, capable of seating, it was about 120 odd people. A purchaser was, as a result of the particular advertisement, attracted to the New York Deli, embarked upon negotiations with the vendor, and ultimately entered into a contract to purchase the particular deli. Now, the contract required a transfer of the liquor licence. At the particular point in time, in New South Wales, liquor licences were granted to restaurants based upon the area of tables and, more importantly, the number of toilet bowls and urinals that the premises had. Consequently, this particular restaurant, the New York Deli, was licensed not for 120 people, but for 84. The revenue, the balance sheet, was all based upon 120 people using the facilities of the restaurant, not 84. Now, despite the fact that the liquor license was attached to the contract for sale, which clearly said there were 84 tables or patrons, not 120, the purchaser proceeded with the purchase, entered into the transaction, and had the licensing police close them down very soon after opening because they had 122 people in the restaurant rather than the 84 that they required. The purchaser then sued the vendor for misleading and deceptive conduct, having been enticed to acquire the business based upon the revenue stream of 120 people as opposed to it really being 84. The case was heard by the court. The vendor argued, well, we didn't mislead anyone. The license agreement clearly stated 84. Whilst the advertisement did say 120, we did have within the contract for sale of business an entire contract clause which said no statement, representation or warranty made by us which is not otherwise incorporated in the contract has any force and effect. As the liquor licence was in the contract and said 84, the mere fact that there was this advertisement saying 120 shouldn't apply. The court, however, said, well, that can't necessarily be right because you have represented through your revenue stream that the business would be satisfactory or would generate a degree of turnover. That degree of turnover is based upon the fact that you have been putting through 120 people, where in fact now the purchaser will only be able to be put in 84 if they are to legitimately adhere to the terms and conditions of their liquor licence. Consequently, your silence in not having brought to the attention of the purchaser that the liquor licence was indeed only for 84 and not a greater number, that was the activity that is misleading and deceptive. Being misleading and deceptive within the meaning of then Section 52 and now Section 18 of the Australian Consumer Law, can you contract out of that? And the court said no. Section 52 and indeed Section 18 of the Australian Consumer Law are statutory provisions which are not able to be contracted out of. Therefore, although one can include a whole of warranty or a whole of contract clause in it, because it's not illegal to do so, it has no impact upon a course of conduct, behaviour, whether through act, omission or silence, which constitutes misleading and deceptive conduct. So we need to have strong regard or clear understanding of what is being represented and to make sure that there is no misleading or deceptive conduct on behalf of our clients. So if you're putting out a tender or expression of interest for a business, you need to make sure that the information concerning the business is accurate. If it's misleading or deceptive in some way, there may be a Section 18 issue. Moreover, predictions of the future reverse the onus of proof. In Section 4 of the Australian Consumer Law, if a prediction as to future takings or future earnings or future revenue is made, it will be the vendors who bear the onus of establishing that they had reasonable grounds for having made that future representation. It is not for the purchaser to show that the mislead or that the representation was otherwise wrong. And a case that establishes that, at least under the old law, was O'Connor and Sons Proprietary Limited and NTAC Clough Proprietary Limited. So in looking at tenders, expressions of interest for a sale of a business, you need to make sure that the offer documents are correct, and that if you specify a methodology by which you will assess a tender or a response to a tender, you need to ensure that you expressly comply comply with it. The case that illustrates this is the case of J.S. Macmillan and the Proprietary Limited in the Commonwealth. In that particular case, Macmillan responded to a request for tender to purchase the business assets of the then Australian government printing service. The request for tender did not warn tenderers that a failure to accept the clauses unreservedly would result in the person submitting the tender being automatically disqualified from consideration. Macmillan submitted a non-conforming tender and was automatically disqualified. Relying upon the then Section 52, Macmillan obtained an injunction under Section 80 of the Trade Practices Act to stop the tender proceeding. His Honour Justice Emmett held that the Commonwealth, who had called for tenders, had engaged in misleading and deceptive conduct. In this particular case, however, Macmillan did not obtain a remedy, as although the Commonwealth had engaged in misleading and deceptive conduct, the particular branch of the government that was undertaking the activity had not done so within the requisite threshold of having engaged in trade and commerce. Therefore, the threshold provisions for the application of the Act to apply did not occur. Another case that illustrates the issue of tenders is that of Hughes Aircraft and Air Services Australia. In that particular case, there was a request for tender that the CAA would conduct its tender evaluation in a particular manner. Indeed, this was the second tender that was issued. There was a request for tender issued, and there were only really two entities in the market, Thomson and Hughes Aircraft. Hughes Aircraft refused to enter into the tender. The Commonwealth approached them and said, well, why are you not tendering? And Hughes Aircraft said, well, you've always used Thomson's. Thomson's are going to get it. We're not going to spend time, money and effort putting together a response to a tender only to be knocked out. The CAA then said, well, no, we genuinely wish to have a tender because we have competitive pricing policies. Therefore, we will judge both tenderers fairly. Despite the representations that this would occur, the CAA breached its obligations by failing to, amongst other things, evaluate the tenders in accordance with the priorities and methodology that it had agreed to and set out in its request for tender, and it failed to ensure that measures designed to achieve strict confidentiality of information in the tenders and proposals were maintained. As a consequence of this, Hughes was able to successfully obtain damages for its cost, time and effort in having submitted its unsuccessful tender. So if you're dealing with vendors that are putting out expressions of interest for the sale of their businesses, be very careful that the vendors maintain and adhere to any methodology of sales evaluation that is specified in their documentation. Another provision to consider is that of whether to grant a purchaser early access to a business. The issue of early access, I suppose, needs to be juxtaposed to observation and training. Are they having access for the purposes of due diligence and observation, or are they having access to actually roll up their sleeves and get involved with the business? To the extent that access is granted for due diligence and observation, it's acceptable. To the extent that the purchaser is actually having day-to-day control, in our opinion, this is something that ought to be avoided at all costs unless and until the contract has been fully and properly completed. It can be difficult with a purchaser coming involved because it could have complications with staff, with clients, and could result in more and greater damage to the vendor should the business sale not proceed than not having involved in the first place. So consequently, do not permit early access. It is better to do not have documents held in escrow. Rather, what you are better off doing is to provide supervised training once the contracts have been entered into and the purchaser has committed to purchase the business from the vendor. On the other hand, though, allowing adequate due diligence is certainly something that is advisable. If you are selling a particular business on behalf of a vendor and it would be disruptive to the operations of the business to allow the purchasers to go in, often what happens is there is a information room that can be established either on the premises or off-site for the purchasers to go in. Having an information room provides for consistency in supply of information and also allows the vendor to know at any point in time what information was supplied to a particular purchaser. These days, again, with computers, actually having an information room can be avoided by all of the information just being supplied electronically. Moving now to the negotiation process. The negotiation of the sales contract is important from both parties to try to get the best deal that is possible. Negotiation is necessary because of the inherent risks involved in any commercial transaction. In an ideal world, the risk pendulum would lie perfectly balanced between the interest of a not so overly anxious vendor and a not unwilling and anxious purchaser. However, in reality, the position between the vendors and purchasers as where the pendulum swings really depends upon the relative bargaining position of the vendor and purchaser. And this is generally not equal in most cases. Due diligence. Due diligence is the process of investigating what it is that is being sold and what it is you may need to buy. We're going to have a look at the process of due diligence, the purpose behind it, who will conduct it, what's it for, where is the information obtained, and some lessons from some cases. Due diligence is detective work. It's doing your homework. It's investigating what there is to sell or what there is to buy in an attempt to overcome unforeseen and unwanted issues arising post-completion of the purchase. And we endeavour as lawyers to deal with this through the contracts. So we've seen the contract process, we've seen how we put this together. This is where we marry our investigation through our clients and put all of the risks of the pros and the cons into the documentation, having regard to the form of contract that we require in regards to, is it a simple, less formal or more formal arrangement. A possible analytical tool or framework that you can employ or you can introduce your clients to employ is that in Australian Standard AS 4360, which deals with risk minimisation and risk assessment. The Australian standard deals with all aspects of risk assessment, and here I am suggesting its use in the negotiation process. So you would evaluate the list of legal issues that need to be analysed. You would look at the risk assessment to determine, is this a commercially acceptable risk? Yes. So you accept it and you monitor and view it within the contract process. If it's not acceptable, then you have 4 options to then consider. How do I reduce the likelihood of this particular unacceptable risk arising? How do I reduce the consequences of the risk should it arise? Can I transfer in full or part the particular risk? And how can I avoid the risk? And there are particular aspects which you can keep going down through. What we then need to do is look at what the legal risks are, analyse them, identify them, and then consider those particular risks in light of those 4 factors. Reducing the likelihood of an event arising, reducing the consequences of the event should it arise, the ability to transfer in full the consequence of the event either through insurance, earn-out provisions, clawbacks, or the like, or avoiding the event entirely. And we do this through due diligence. By our due diligence, we can reduce the likelihood of an event because we are forewarned, therefore forearmed, and we can address the issue. But unless we do the due diligence, we don't know what events there might be. The second aspect is to reduce the consequences of an event. Having ascertained what events we need to consider, we can reduce the consequence of the particular event should arise through a warranty, through a liquidated damages clause, through restraints of trade by preventing the likelihood of the vendor going back into the market and competing against the purchaser, through post-employment provisions, and through exclusion clauses and a myriad of other documents. We can look at transferring in full part or all of the consequences of the event. We can have a firm price. We get our money, the purchaser pays what the purchaser and vendor agree upon as being paid. The vendor takes the money and walks away. We've transferred the consequences fully. We can have a fixed price. The difference between a firm and fixed is that firm is known, fixed is referable to possibly further revenue coming through particular events. It's based upon variable parameters or known consequences. And then we can also introduce an earn-out by a price based upon the post-acquisition profits of the business so that the seller shares in or on the growth of the business along with the purchaser. Fourth aspect, avoid the event occurring at all. Don't proceed with the sale or purchase. Simply move on. The purpose behind due diligence is to minimise risk, to inform the purchaser of the chances of a particular event arising so as the purchaser can minimise their potential loss. Further aspects of this is to confirm what the business contains, to confirm what the soundness of the company and the contingent whether there's any contingent liabilities if you're buying shares in a business, to avoid misunderstandings as to the type and the condition of what is actually being bought. Investigate the state of the management. Investigate the harmony of the employees. Identify the extent and quantum of any contingent liabilities, court cases, claims of action and the like. The Following purpose behind due diligence is to essentially gain information that will be useful for the parties determining the value of the assets being sold and bought, defining the representations and warranties, negotiating price considerations. All of the aspects that we've looked at as the negotiation process, how we put the drafting together, is all arisen from the due diligence process. Due diligence is generally undertaken by the purchaser through a due diligence committee comprising a representative of the purchaser, purchaser's lawyers, accountants, and sometimes advisors. The due diligence process is, as we've seen, one of detective work and investigation. It's about obtaining a target to acquire, preliminary investigation of the target, forming a due diligence committee, the due diligence committee undertaking the necessary detective work, the due diligence committee using the results to negotiate a purchase on satisfactory terms, and then ultimately acquiring the business that was the subject of the particular due diligence investigation. Due diligence is important. A matter that I was involved with a number of years ago, where I was fortunate enough to be involved in an acquisition of assets in Australia where the subsidiaries had assets in Fiji, and we needed to undertake the hard and onerous task of doing due diligence in Fiji for a week or so. We were given access to all the information and we looked around, and whilst waiting in the waiting room, I was looking at the certificates that were on the wall, and I noticed that there were a number of certificates of incorporation of corporations that we'd never heard of, and they were not part of any of the due diligence information. So when concluding our report, I noted these particular companies and we raised the questions, only to find that two of the particular companies actually own the intellectual property of the assets that were crucial to the venture we were acquiring. And the parties, the vendor, had forgotten to mention this fact because they'd just forgotten about it because they'd been set up 30, 40 years previously, and they were not on a day-to-day radar for the vendor. But if it hadn't have been for us being there, by doing a simple observation and noting what we'd observed and reporting on it, that particular aspect would not have come part of the due diligence and would have posed a problem for our purchaser going down the track. Information from the due diligence is generally obtained from the vendor. Also, the purchaser should use their own knowledge. You should do due diligence from industry bodies, investigate information and relevant material from trade magazines, speak with consultants, and where possible, and if permissible, talk to customers, clients of the particular vendor. The lessons to consider in regarding due diligence is that it is important to have a due diligence agreement, which, like any form of contract, is a checklist of who's to do what, when are they to do it, and how is it to be done. Determine the proper areas of due diligence. Ascertain whether the ultimate decision to proceed will be an objectively determined or subjective. For example, in STS Corporation and Pasdonne, the clause said the due diligence must ultimately be to the absolute discretion and satisfaction of the purchaser. And there is nothing wrong with that, provided both parties are agreeable. If, however, a more objective measure is to be established or agreed upon, that needs to be set out in the contract. In undertaking any due diligence, both parties need to minimise the disruption to the vendor's business, because it's in both the vendor and purchaser's interest to ensure that the business is maintained at a profitable and an efficient, productive level, whilst the vendor and purchaser are negotiating the sale. It's crucial, though, to get a clear understanding of what the due diligence is about. And an example of this arises in SDS Corporation and Pastoni Proprietary Limited, another, a 2004 Western Australian Supreme Court case. In 2002, SDS and Pastoni entered into a contract where SDS agreed to purchase the assets of Pastoni and assume certain liabilities of Pastoni on the terms and conditions contained in the agreement. And there was conditional upon the sale and purchase of those particular assets occurring. Mr. Rea was a major shareholder of Pastoni, and he was also a managing director. He also agreed to enter into a license agreement with SDS under which he would license particular patents that were pivotal to the Pastoni business. SDS argued that Pastoni and Rea, its main shareholder, had breached the terms of their sale agreement by Pastoni and Rea failing to provide information to SDS to facilitate and allow SDS to conduct its due diligence, and as a consequence of SDS not being able to conduct its due diligence, it therefore prevented SDS from being able to complete its purchase of the business. The matter came to court on numerous occasions. Parties spent substantial sums of money only to have, 2 years later on, an order for specific performance being imposed on Pastoni and Rea for the particular information that SDS had required to be forwarded to them in order for SDS to determine whether it would continue with its due diligence or not. The case is illustrative of the fact that you really need to be clear as to what it is the due diligence is going to do. And if there's certain information that you don't want to disclose, then the vendor needs to make sure that that is clearly and adequately and succinctly set out in any due diligence agreement that takes place. So what we've looked at in this session is the process of tips, traps, and tactics of buying a business in regards to the legal steps that us as lawyers need to take on board either for our vendor or purchaser clients.